All right, good afternoon, everyone. Thanks very much for joining us. My name is Andrew Schaefer from Trafalgar. I'm based in Trafalgar's Johannesburg office. It's 5 o'clock, so we'll kick off and we aim to finish punctually by 6 p.m. I'd just like to welcome my colleagues and our special guest, Zelinda van der Merwe, for joining us this afternoon. Firstly, Zelinda is co-founder and director of TVDM Consultants. They are specialist sectional title and community scheme attorneys based in Cape Town, I believe. But, we've worked closely with them with modernizing the conduct rules for many of the schemes that we manage. So we thank Zelinda for joining us and to talk about a very important topic this afternoon, navigating the complexities of body corporate meetings. And the reason it's so important is, as you'll hear from Zelinda, is it's really important to understand the just the mechanics of arranging legally compliant meetings, what that involves, how to take legally binding decisions, and how to mitigate the risk of not doing it properly so that those decisions can be challenged and overturned, and thereby wasting time and causing frustration in the process and not achieving the objectives of the meeting and the resolutions concerned. So hopefully you'll enjoy this afternoon. I think it's an important topic, and it's certainly one that you will see has got quite a lot of detail to the way meetings need to be convened, the quorums, and some of the decision making. And it's all about just collective learning, trying to share information. And I think the more effective we are as trustees and practitioners in the community scheme space, the more effective the administration of community schemes and the better for all the residents concerned. Just a few comments by way of housekeeping. I mentioned we'll try and keep it tight to 1 hour, so we'll end punctually at 6. The session has been recorded. We do upload the recording to our training website, which is training.trafalgar.co.za/webinars. The links will be at the end, but the recording will be available. If you would like us to email you the recording together with the Q&A, please just put your email address in the Q&A. We'll download the Q&A, and Karine and her colleague Aidan Roman will then circulate that for easy reference. If you'd like to be added to our newsletters, please just put a comment as well. Our newsletters have got training related information and crosswords and other information that I think would help trustees and residents who would like to be informed living in community schemes. There'll be a short pop-up survey at the end. Won't take more than 30 seconds to complete. But if you'd like to give any comments about improving these webinars or any topics you'd like us to cover during the year, please just drop a short note there. We'll pick it up, and we certainly try and respond to feedback and make sure that we cover topics that are of general interest to those that follow our webinars. And we do try and have webinars monthly from February to November. So we've started now the 2024 series with this particular webinar being our first in 2024. I think that's about it. So Karine, I'm going to hand over to you. I will share the presentation, and unless you'd like to, Karine is going to start with the introduction on, some of the background and the legal provisions in terms of community scheme meetings, and then thereafter we'll hand over to Zelinda to go to a low level of granular detail. So Karine, I will hand over to you.
Thanks, Andrew. If you can, or Peter can maybe just share the slides. There's just some problem with my sharing.
Right.
Okay, but let me make a slow start. So basically, we are looking at body corporate meetings. And what types of meetings do we get? We get trustee meetings, and then we get the body corporate meetings who are all the owners. Sometimes people incorrectly refer to the trustees as the body corporate, or even sometimes to the managing agent as the body corporate, which is not correct, because the body corporate is all the owners together form the body corporate. So the body corporate has some meetings that they hold that we will be looking at. The first one being the very first annual general meeting. In general terms, we call it the inaugural meeting, just after a scheme have been established. And then we get the annual general meeting. That's the one that we're basically going to look at tonight. That is the one that we have every year with a prescribed agenda. Then there's special general meetings. where certain special items can be discussed. A special general meeting does not mean necessarily that there's a special or unanimous resolution on the agenda. It could be an information meeting. It's any meeting basically that is not the annual general meeting is called a special general meeting. We have different resolutions that are being passed at these different meetings, and we have available for you on request an easy guide to resolutions that we can send to you if you send it through. If you just email us or put it on the Q&A, then we can send it through to you. So yeah, if we can just move to the next slide, please.
You should see it now, Corinne.
Okay, I'm still seeing the first one, but let me continue. So basically what we're looking at is how to call a meeting, general meeting. The trustees have the right to call general meetings, but the owners have a right as well. But one owner on their own cannot call a general meeting. You have to get backing in terms of prescribed management rule 17.4 of at least 25% of the total quotas. So if you want as an owner to call a general meeting, you have to get a petition basically drawn up asking for a meeting. You need to get at least 25% in PQs of the owners to sign that petition to request that meeting and specify exactly what you want to discuss at that meeting. And then the trustees have 14 days to call that meeting, with the emphasis on call the meeting. They don't have to hold the meeting within the 14 days. They just have to call the meeting within 14 days. So that's just some background on general meetings. If I can now hand over to Zelinda, who's going to take us through the procedures of general meetings.
Fantastic. Thank you so much, Corinne, and thank you, Andrew, Peter, and Corinne, for the invitation. It's always a pleasure to engage with you on your webinars. All right, so sure, general meetings. I feel like there is supposed to be a AGM season or an SGM season, but I think it's also 12 months of the year. I think we're just constantly busy at meetings. My colleague Nicole Null is actually at quite an acrimonious one that is starting at 5 o'clock as well, where the owners are wanting to pass a motion of no confidence. I'm going to chat about that in a little while. Peter, I know that you're sharing the screen. If you don't mind moving on to the next one for me, thank you so much. Great. Okay. So when you as the trustees, or even as members, as Corinne mentioned, decide that you're going to call an annual general meeting, a special general meeting, or even a trustee meeting, you can't simply say, okay, next week, Tuesday, we're going to call a meeting. You have to take into consideration that there is a prescribed notice period for meetings. And if you do not comply with those notice periods, you are going to invalidate the proceedings of the meeting, and you're going to invalidate resolutions taken at that meeting, unless all of the owners agree to that error, or it has been made in a reasonable manner. In other words, every single effort has been taken to call the meeting correctly. And of course, not calculating the notice at the start is most certainly not taking every reasonable step to ensure that there is compliance. So very important to know that you have to use the right notice period. When I practice as a managing agent, I would always take my hard copy calendar, or even the calendar on my email, and I would go and count back the days. In other words, to see if we're wanting to hold a meeting on a certain day, is it going to comply with the notice? Alternatively, if you're being asked to call a meeting, go and have a look at when you could possibly send out that notice. Just a reminder that you can't simply send a notice out in the same day. You still have to get instructions from the trustees. You need to draft the notice. You need to ensure that everything that needs to be included in the notice is in that notice. So it's not something that happens overnight, and you have to take into consideration the notice period. When you're calculating that notice period, you have to exclude that the day the notice is sent, but you include the day of the meeting, except if that is on a weekend or a public holiday, and then the meeting will fall on the next day. We'll chat about adjourn meetings as well, and then that notice period becomes quite important there as well. When you send the notice, you also have to take into consideration how you're going to be sending it and factor into account the notice period that you're going to need to have there. I know that all of us think about having a meeting on a Saturday as being shock horror. I've had a couple on a Saturday, and the attendance has actually been quite good. But again, it depends on the scheme and the composition of the members or the proxy holders in that scheme. Peter, you can move on to the next one for me, please. Thank you so much. All right, so the most extensive notice period that we have is 60 days. It's not something that we deal with very often. It's actually a requirement when we install prepaid meters. So it's a statutory requirement that you have to call a notice on 60 days, and that the notice, as well as the proposal, is not going to contravene a lease or the Rental Housing Act when it comes to tenant protection if a unit is tenanted. So very important to remember that. We can't call that meeting on any shorter than 60 days. That's pretty much the only one where such a long notice period is required. We then have the normal 30 days for any meeting where there is going to be a special or unanimous resolution. And as Corinne said, it's not necessarily 30 days for a special general meeting, because the Act says that any meeting that is not an annual general meeting is called a special general meeting. So just a reminder that the requirement there is 30 days. There are exceptions when this 30-day can be shortened, and we're going to touch on that in the next slide. Peter, if you won't mind. 14 days, that's the one that we're probably all most aware of, and that's our annual general meeting or our special general meeting where there are no special or unanimous resolutions. Alternatively, where there aren't even any resolutions that are being tabled. It is very often the case that the trustees decide to call a special general meeting, either informally or formally, simply to have discussions and maybe to take directives. So that would be 14 days. Now we're going to look at the shorter notice period that is set out of the Act, and that is 7 days. And that needs to be called by the trustees on a trustee resolution, which is a majority trustee resolution, bearing in mind that any trustee with a direct or indirect interest in the calling of that meeting and the reason for calling of that meeting would need to recuse themselves. And this is where the circumstances are urgent. Now, the Act does not set out what is urgency, but one can imagine if there is any emergency work that is required to be undertaken to the common property, that could be seen as urgent. I have had situations before where members have requested meetings be called on an urgent notice period to remove trustees, but as Corinne said, only the request has to go through the trustees to call that meeting. And even if the owners have to call the meeting themselves, if the trustees fail, the 7-day period is only viable if the trustees are going to call it on a trustee resolution. Peter, the last one is on the next slide. And that is where an even shorter notice period is called than 7 days. I personally haven't seen it in practice. I think people get a little bit nervous when it comes to notice periods. But if all owners in writing waive their right to a notice, and you'll recall that when you look at the prescribed agenda of the annual general meeting, there is a statement that says waivers of notice. If any of you have gone to a meeting where you have been made aware that owners have waived their right to receive a notice, I'd be very interested to see if you put that in the chat. But generally speaking, owners do not do this, which means that if a shorter than 7 days period is required, the written consent of all the owners is going to be needed. With regards to any round robin resolution or any informal meeting, as I mentioned earlier, it is possible to have a shorter notice period. With an informal meeting, you won't have any formalities, obviously, no votes, no quorum, no attendance, no minutes, all those fun things. And then round robin resolutions are when resolutions are taken in writing, and you can take special and unanimous resolutions in writing. There is no prescribed period for a notice period, and one would generally assume that once you get the required number of owners responding, that notice period would then come to an end. But we do generally advise that if you are able to afford the 30 days to rather go with that route, or the 14 days if you're able to go with that route. We can go to the next one. Format of notices. Okay, so I've seen quite a lot of interesting notices over time, and it's quite crazy that such a small thing as simply the formatting of a notice or leaving a particular point off the notice can have such an impact on the outcome of the meeting and the validity of the meeting. So there's no prescribed format per se for a meeting, except where it comes to the prescribed agenda items for the annual general meeting that is set out in Prescribed Management Rule 17, and as Corinne mentioned, the inaugural general meeting or the first general meeting. Of course, those can be added to, but they cannot be taken away. It is advisable that when you prepare a notice that you look at the order in which the business is going to be dealt with, and very often deviations are required from the prescribed agendas in order to sufficiently cater for a meeting. One of my bugbears is dealing with the audited financial statements after a budget. My preference is that we deal with financial statements before a budget. I'm sure Trafalgar would agree as well. Now, when it comes to a notice prepared by the members, you have to ensure, as the managing agent or the trustees, that the notice requesting the meeting, in other words, the 25% request, has been done correctly in terms of the Act. And it doesn't start and stop with only ensuring that registered owners have actually made an application for this meeting, but rather that they've prepared a notice, and the notice deals with the items of business that they want to deal with. And way too often do I receive requests for member-called meetings where what they are proposing for the members to discuss and or vote on is completely out of line with the Sectional Title Schemes Management Act and cannot be dealt with. So it might seem like an easy thing to call a meeting, but it most certainly is not. The notice must also specify the date, of course, the time, the venue, and of course, if it's going to be an online meeting. I have no issue if the original notice goes out with an online meeting, let's say Zoom, but then the adjournment happens on Microsoft Teams because there's an issue with Zoom. It's still an online meeting, and both of those platforms are readily and freely available, but you can't go from a physical venue to an online venue, or from an online venue to a physical venue. Of course, you can have a hybrid, and that would be where you have a physical meeting, but some owners and proxy holders attend remotely. Teleconference call or Zoom or Microsoft Teams. I haven't been to a meeting in very long where an owner has called in on the telephone, but it is still quite possible. And then, of course, if you're going to have a physical meeting, you need to ensure that the meeting venue is within the magisterial district of the body corporate as well. And that is something to take into consideration, especially if you've got a bigger scheme where you do need a bigger venue. And of course, if you're having an evening meeting, people are not going to be quite happy to climb back into their cars after a long day to drive quite a distance to have a meeting. The notice must, I cannot emphasize this enough, it must have certain documents attached to it. The first one is the prescribed proxy form. It is possible to receive a proxy form in a similar format as the prescribed form. Let's say somebody can't print it out or scan it in or something along those lines. If you're dealing with an annual general meeting or a special general meeting to remove trustees, you need to have trustee nomination forms. And then, of course, resolutions, if there's resolutions to be taken, special resolution to extend a section, for example. And then the documentation, or at least summaries of what the members are going to consider and vote on. That would be the budget, the financial statements, the trustees' report. Gone are the days where the agenda could say XYZ to follow. That cannot happen. Everything has to go out on the same day, which is why it's often the case where both special business and ordinary business is going to be held, that the special business is sent out on 30 days notice, but the ordinary business is sent out on 14 days notice. In other words, two different packs, but for the same meeting per se, and that would comply with the notice period and, of course, having the documentation ready. What happens if this isn't sent or it's sent later? As I mentioned earlier, a meeting can be invalidated. I've had quite a few annual general meetings called off when budgets have only been sent out a day or two before, or worse, a budget has only been handed out when the owner signed the attendance register. That obviously is not on at all. The reason for the notice is to ensure that an owner has time to prepare, that they've got time to decide whether or not to attend the meeting and make the necessary arrangements, alternatively instruct a proxy, or to get advice if they need to prepare for the meeting. Peter, you can pop off to the next one. Methods of delivery. So this is something that a few of my colleagues and I have debated on for a long time. I believe that Corinne and I are on the same page when it comes to this. But when it comes to any meeting where there is a special business, a unanimous or a special resolution, it is still a requirement, as archaic as it might be, that the notice of that meeting and that special business has to be sent out via prepaid registered mail. Sorry, I forgot the registered there. Prepaid registered mail, alternatively hand delivery to the section or the owner. It's not possible to only email those. Now, if you're anything if you're in a situation anything like mine, where 3 of my local post offices have closed and I have to drive a very, very far distance to the post office, I personally don't see the harm in not having the notice delivered by a prepaid registered mail, but you must certainly make an alternative. Now, we've engaged previously with a few managing agent colleagues as to whether or not they've used the prepayment email format. Alternatively, there are a lot of formats of online platforms and forums that are able to make notices available in such a way that it's 100% certain that it actually gets to the owner on the other side, or the registered authorized person on the other side. When it comes to notices where it's only required to be emailed, my advice always is to add a delivered receipt, a red receipt. If you get any undelivered or bounce back, to follow up with those, check that the email address is correct, check that you've got the correct person that you're emailing it to, that they haven't put a business email address and they don't work there anymore and it's bounced back, or anything along those lines. You cannot really rely on an owner updating this information, although it is a legal requirement that they do so. So there is some legwork that is required by the trustees or the management of the body corporate. Of course, there are platforms as well that allow for red receipts. And I heard from a managing agent colleague of mine that on a certain platform, you're even able to see how many times somebody has opened a document and how long they've been on the document. So it can get quite interesting. I've also attended meetings where they have made the hard copies available, perhaps at the complex office or the scheme's office, that people can go and collect, or at the meeting, or have only asked members who would prefer a hard copy and the rest to get emailed. But the biggest issue is you need to make sure that as the person sending out the notice, or responsible to send out the notice, that you've got proof that it's been delivered, and that you're able to have proof that it has gotten to the other side. For example, what you would see on a registered mail slip. When I was a managing agent, the amount of undelivered or uncollected prepaid registered mail envelopes that came back months after meetings was absolutely ridiculous. So hopefully everyone's records are up to date with regards to the contact details of owners. Again, what happens if the notice is not sent in this fashion? The validity of the vote most certainly can be challenged. If the notice is not received, and again, I'm sure we've all been to meetings where somebody or a group of people have said, oh, I haven't received the notice. My cheeky question or answer is always, how did you know that you had to be here? Or how did you get here today? Which the people don't necessarily like to hear on the other side, but they have to show their prejudice as to why them not receiving the notice has had this negative impact on them. And then, of course, the chairperson needs to take the decision as to whether or not this meeting has called correctly and whether or not the meeting can continue. Cost recovery. A lot of body corporates have stopped sending prepaid registered mail notices and hard copy notices and printing out hard copy notices because of the cost of post and petties. It is very expensive to arrange a meeting, especially if you have to pay for a platform or hire a venue, deal with some catering and all of those fun things. You can write into your rules that you recover costs from owners, especially if somebody insists on getting a notice via hand delivery or in a hard copy when they don't have to. And then with regards to who the notice goes to, I know that all of you are sitting in shock and horror that the notice has to be sent out to the bondholders. Yes, it does. I'm not going to throw stones at you if you don't do this. It is something that very often doesn't happen in practice, but it is something that can invalidate the meeting. And of course, if the managing agent is not the person sending out the notice, or the trustees not sending out the notice, for example, a group of owners, the trustees need to receive a notice, and then it has to go out to all registered owners. And then, of course, that proof of delivery becomes relevant there. Registered owners, I again have been to many meetings where somebody attends a meeting that is not yet the registered owner. In other words, the sale has not yet transferred, but in their minds, they are the member, they do have the vested interest. If that is the case and they're not the registered owner and that information has not been taken to the body corporate or recorded with the body corporates, they would need to be in attendance or represented at a meeting by a proxy. Peter, we can move on to the next one. Proxies. Okay, so I mentioned that the prescribed proxy form has to be used, but it is most certainly possible to use a different format, provided all the information is there. And the two most important things of a proxy is that the actual registered owner completes that proxy and the proxy holder accepts the appointment. Attending the meeting, signing the attendance register, being part of the quorum, participating and voting at the meeting is most certainly tacit acceptance of the appointment, but a proxy form does have to be properly completed. A proxy form that is left blank is not something that I personally see a lot of anymore. There used to be quite a lot of this in the days where proxies were not limited. So for those of you that don't know, one person can only hold 2 proxies, and a proxy represents a member. So if I own 3 units in my scheme, I can't give Peter a proxy, Andrew a proxy, and Corinne a proxy. I can only give one of the 3 of them my proxy for all of my units. If I own a unit between myself and my husband and myself and myself and my daughter, that would be 3 members, 3 different registered entities, and then I'm able to give 3 different people those proxies. If you own a property in the name of a company, a trust, or a CC, or co-ownership, you also need to hold a proxy, because the body corporate has to be aware of who has instructed you and if you've got valid instructions to actually attend the meeting, and that then needs to be accompanied with the proxy. Proxy canvassing and farming. It is still possible to proxy canvass and farm. I have gone to meetings where just before the meeting starts, somebody is rushing around asking who doesn't hold 2 proxies yet, can we give, this proxy? But it is important that on the proxy form, there is a power of substitution. This power of substitution is not something that is on the prescribed proxy form, and this is something that should be added. It's also a very good idea to have a proxy of substitution if your original proxy holder is not able or available to go to a meeting anymore, if you've had a falling out and you've forgotten to change the proxy. Very good idea to have that power of substitution, that the proxy holder can delegate it. Alternatively, the body corporate can delegate it. You can even limit it to who you want that delegation to go to. The proxy form has to be sent to the body corporate's domicilium address 48 hours before the start time of the meeting, but it can be given to the chairperson at the start of the meeting or just before the start of the meeting. And that right of receipt can be delegated to, for example, one of the other trustees or the managing agent. What happens if I don't know anyone to give a proxy? A proxy holder does not need to be a member. It can be a tenant or a family member, an estate agent, you name it, but it cannot be the body corporate's employees or the managing agent or a managing agent's employee. Peter, you can move on to the next one. So we've just dealt with who can be a proxy holder. Very infrequently, we get the question of what happens if an owner holds a general or a special power of attorney. A proxy and a power of attorney is not the same thing. The banks in their bonds hold an automatic power of attorney, which means they can attend a meeting and that power of attorney will override a proxy. And if you have, for example, an estate, you'd need to prove that there is a letter of executorship and the executor is actually the representative, and that might override a proxy. A new owner of a section might override a proxy if there's a power of attorney that's part of the transfer. And then I mentioned the trust company, CC, and joint ownership. A few of my colleagues and I had a quite hectic, long debate about whether or not you need the supporting resolution attached to a trust company, CC, or joint ownership proxy. And after doing quite a lot of research, we are quite comfortable in our opinion that it is required. What happens if you're at a meeting and somebody has not completed, oopsie, if we can just go back there. If somebody has not completed a proxy form or has not given a resolution, they obviously can't count towards the quorum. Again, I've got no issue with them attending, provided that they know that they're not participating in such a way that is going to have an impact or an effect on the voting. It is possible, and again, it comes down to the chairperson, the nature of the scheme, the nature of the individuals, that you can allow an owner to be represented, but then require that the documentation that is required to be sent immediately after the meeting to validate any vote. Can you withdraw your proxy? You most certainly can. Let's say, for example, you couldn't attend the initial meeting, but you can attend the adjourn meeting and the proxy form applies for the adjourn meeting. You can withdraw that proxy in writing as an owner and attend the meeting yourself, and then your attendance will override the proxy. The proxy limitation, I'd just like to touch on again. A lot of people have asked me why there is a proxy limitation. And when the very intelligent drafters of the legislation proposed a proxy limitation that was a lot more open than what it currently is. There was somebody on the parliamentary committee that had a negative experience with proxy canvassing in their scheme and suggested that a much lower number be used. I think managing agents and trustees have come to grips, or at least I believe they have, with how they can get around, in inverted commas, proxy limitation. I don't think it is such a massive issue anymore, but it most certainly is something to take into consideration. And on that note, if you're already holding a proxy because your unit is in a trust, a company, a CC, or joint ownership, you can only hold one other proxy and not two other proxies. So that's something to keep in mind. Peter, we can move on to the next one. Chairperson. So who is the chairperson? The chairperson of the trustees is automatically the chairperson. It is, however, possible for the members to make a decision as to who to chair the meeting. The Act says if necessary. Now, my interpretation has been, and I stick to it, is that if the chairperson is not willing, is not able, or is disqualified from acting as the chairperson of the meeting, then a proposal can be made to the members for a different chairperson. I don't immediately take it to a vote. I first ask if there are any objections, and we deal with the objections, because very often a meeting's nature is such that everybody is just anti the trustees, anti the chairperson. They don't want them to deal with the meeting, but in some instances they have to, because they're the ones with the intimate knowledge of what is going to be presented at the meeting. Some of the duties and responsibilities of a chairperson, or the do's and don'ts I like to call it, is that as a chairperson, you cannot influence how your members are going to think and vote. In other words, as a chairperson, I can't say, well, I don't know about the rest of you, but I think this extension of a section is a brilliant idea and I'm going to vote in favor of it. You cannot do that. You also must ensure that order in the meeting is maintained. I'm sure you've been to many meetings where somebody says, order, order. It's very difficult sometimes to maintain order in a meeting. It is possible for the chairperson to adjourn that meeting for a short while, or even to a different date and time if they're not able to maintain order in a meeting. I did that yesterday, actually, where after multiple requests and multiple threats of asking people to leave, we simply couldn't get order and the meeting had to stand adjourned. So that is very important to know what your responsibilities are. It's very difficult being the chairperson, especially if you have asked your managing agent to facilitate a meeting. Many of my managing agent colleagues use the word of facilitation. As a portfolio manager or the managing director of the company, they facilitate the meeting. I never quite like the term facilitation, but I think it does sum up very nicely what they're trying to achieve. And if you are a managing agent that is facilitating a meeting, you're having to answer questions, chair a meeting, keep track of quorum, keep track of questions, look for answers, take the minutes, make sure it's still busy recording. It's an absolute nightmare. So where it is possible, the chairperson of the trustees should chair the meeting. Alternatively, another person should be available to chair a meeting, that whoever has to deal with the administration and management of the meeting is able to do so, unless there's a platform or a software program or something like that that can assist. It is possible to have professional trustees as a whole, and it is possible to have a professional chairperson of a meeting. That does not mean that that person is chairperson of the trustees. It just means that they've been appointed to deal with the business of a meeting. Whenever we get asked to be a professional trustee or a professional chairperson for a meeting, or even to attend a meeting to answer questions, I always ask, what's going on? What's wrong? What's wrong at this body corporate or at this meeting that you're going to need somebody like me to chair the meeting or to attend the meeting? Sometimes it's just to help with administration, and other times it's because there is a bit of a bun fight going on. Peter, we can go to the next one. Voting. Okay, I still go to meetings to this day where voting is done by a show of hands. There is no longer a vote by a show of hands. Body corporates most certainly can change their management rules, but I haven't seen a management rule that has allowed this. And there's also no vote by a poll, because the alternative to a show of hands used to be a demand for a poll or declaration of a poll. Voting cards have to be used. There is no format as to what a voting card needs to look like. It can be done online. It can be done on a cell phone. It can be done on a computer. It can be done on a piece of paper. I've gone to many meetings where a little raffle booklet of voting cards have been handed out to owners, and it's quite nice to say the pink card is for the budget, the green card is for the election of the trustees, and not to confuse anybody, but that is a lot of administrative work and of course costs involved in dealing with it that way. I have also attended meetings where the Zoom or Microsoft Teams chat function has been used, or where the meeting has been recorded and people have raised their hands, either physically, alternatively via one of the emoticons, or even noted in verbally what the outcome of the vote was. I don't particularly like it, but it is reasonable. And if the meeting is properly recorded, then that recording is made available to everybody. And we can talk about recordings being made available to everybody for forever. We won't deal with it in this particular meeting. How to calculate votes. A trustee resolution is a simple majority. If the trustee has a conflict of interest, either direct or indirect, they have to be recused, not only from the decision-making, but the discussion as well. An ordinary resolution is a simple majority calculated in participation quota, so 50+1 of the quorum. A special resolution is 75%, both in participation quota and in number. So one member, one vote. So if I own 15 sections in one name, I am still one member. And in a scheme where one person or a group of individuals own multiple sections, it does sometimes make special resolutions quite difficult or impossible to achieve. And then the lovely unanimous resolution that needs a 100% vote of an 80% quorum. And we've received the questions before. If, for example, we've got an 85% quorum, can we ignore that one owner that has voted no? No, you can't. You have to get the votes out of all the owners that are there. You are able to take a resolution in writing as well. A trustee resolution can be done in writing, majority. Special can be done in writing, 75% of all the owners. And unanimous resolution can be done in writing, 100% of 100% of the owners, which is obviously quite challenging. People that cannot vote, you cannot vote if you've got a judgment or an order against you, not just if you're in arrears. So that's something to keep in mind, and that's only for ordinary resolutions, not for special unanimous resolutions, and not if you're a trustee. You cannot pass essentially an ordinary resolution in writing because you would need 100% of the members to waive their right to a notice. It's not a simple majority that directs the trustees in the form of an ordinary resolution in writing. The outcome of the resolutions have to be announced during the meeting, which is why it's also very important to ensure that the person that is capable of dealing with the running of the meeting or their people assisting them are able to do so in a manner that the votes can be announced. I always like to say that the voting is subject to confirmation, and the managing agent can go back to their office the next day or after the weekend or whatever it might be, just to go and double check, looking at the proxy forms to make sure that people that have exercised the votes have done so properly. The only danger in that, however, is that once the meeting is done and you find out that the outcome is very different to what it would have been at the meeting, you are going to have to go to a fresh meeting again. For example, election of trustees, determination of number of trustees, approval of the budget, one of those items of business. The outcome of the vote must also be detailed in the minutes. There's no anonymity when it comes to voting outcomes, and those voting outcomes are part of the body corporate records, and any owner or person authorized in writing can request a copy of it. So there are no secret ballots. If you're going to dispute the outcome of the votes or the validity of the votes, first do so internally, and if you're not successful with the internal process, you can approach the Community Scheme Ombud Service. You can deal with a shortcut process if you're not able to obtain a resolution, special and unanimous, by approaching the Chief Ombud directly in terms of Section 6(9) of the Sectional Title Schemes Management Act. The rest, the disputes, would be an application made in terms of Section 38 of the CSOS Act for one of the orders in terms of Section 39 of the CSOS Act. Peter, we can move to the next one. Minutes. Okay, so I thought when I was no longer a managing agent, I was going to say goodbye to minutes forever, but that is not the truth. I still get paid, believe it or not, to take minutes at meetings, either because the meeting has been acrimonious and they want an independent person to do it, or the managing agent requires the assistance, or a certain style of minute is required, or the minutes are needed for the purposes of a dispute. Minutes are not a transcription of the meeting. It is only supposed to be proposing a motion and announcing the outcome of the motion. You can have a short description of any particular items that were raised for discussion, for example, a budget, or any important items that might have resulted in the outcome of the meeting, but minutes are not a he said, she said. So if you go to your next annual general meeting and your comment about the grass is not as green as it used to be last year was not minuted, please don't ask the managing agent or the trustees to minute that. That is not what minutes are supposed to contain. The recording of a meeting, minutes must be capable of being reduced to writing. My preference is that it is immediately after the meeting. When I say immediately, I mean as recently as possible, reduced to writing. I do think keeping it electronically solely, in other words, only an audio recording or only a recording on Zoom or Microsoft Teams, is a bit challenging, especially if somebody does request that. They do have the right to get it in writing. When I was a managing agent, we still used to print out minutes hard copy in those Horters minute books, which I understand are ridiculously expensive. So, you know, that is something to look at in the format of which your minutes are going to be kept. Minutes must be made available within 7 days of the date of the meeting, that is 7 calendar days. And it might sound like a while, but if you're a managing agent or portfolio manager that manages multiple properties and goes to multiple meetings and has to deal with hundreds of emails and telephone calls, getting minutes out is one of the least favorite things to do. And very often not getting the minutes out in time will also result in action items not being attended to. So if you are the trustee responsible to take minutes, the secretarial function or the managing agent, make sure that you put a process in place for yourself that you don't lose track of the action items or lose track of the minutes later on. And if you're anything like me and your memory fails, you don't want to have to go and decipher your doctor script a couple of weeks after the meeting. How long must minutes be kept on record? Nicole Tavares and myself spent an inordinate amount of time scouring through the SDSMA, and we see that the provision for minutes being kept in perpetuity is no longer in the SDSMA, but it is advisable that minutes are kept for as long as any other record is kept, if not longer, especially when it comes to dispute resolutions. I've dealt with CSOS matters where the history is 20, 30 years back, and if you're not able to have minutes, it's going to be incredibly difficult to solve a problem. We can move on to the next one. So this is, I think it's my last slide. I just wanted to touch on a couple of hot examples that we've been dealing with. The first one is solar installation. It's not as hot, excuse my pun, as it was a few months ago. But when it comes to solar installations, you need to make sure that you deal with it with the correct notice, you deal with it with the correct level of resolution, you deal with it at the correct meeting. Our recommendation is that if an owner is wanting to install solar, that the area upon which the solar is going to be installed is created as an exclusive use area. The easiest way that can be done is in the conduct rules. That requires a special resolution either at an annual general meeting or special general meeting, or in via round robin, 75% votes. If the body corporate is going to do it, that would be seen as a improvement or alteration to common property, either reasonably necessary or not. And interestingly, if it is an improvement to common property, or if the installation is done by the body corporate, then that vote cannot be taken on a shorter notice period, and it has to be taken at a physical meeting. So these are some of the things that you have to take into consideration. The Act, we always say, is quite simple to understand, but there's quite a few little intricacies that we need to be aware of, little tips and tricks of the trade when it comes to potential items that may invalidate a meeting. When can owners call meetings? Corrine set it out very nicely as to how these meetings can be called. The one that we deal with the most often is when owners are wanting to remove trustees and they don't want to wait until the annual general meeting. So the owners, when they get 25% of the total participation quota, not tenants, not residents, not non-registered owners, actual registered owners or duly authorized representatives of the owners, to properly request a meeting in writing, and the managing agent or the trustees have an opportunity to validate that, then the trustees can call the meeting within a 14-day period, as Corrine pointed out. And if that does not happen, the owners can go ahead and call the meeting themselves, which sometimes can be a bit of a challenge if they don't have all the owners' contact information to send the notice out, which it must be provided to them in terms of the prescribed management rules, at least access if there is a legitimate reason in terms of POPI. And then, of course, you need to make sure if you're an owner calling a meeting that you do so 100% by the book, because the smallest thing can unfortunately overturn all that hard work that went into calling a meeting. The agenda of meetings. So when it comes to an owner-called meeting, the owners need to determine what is going to be in that agenda. Again, it needs to be something that can legally be dealt with under the Act. Trustees can set their own agendas in terms of their own discretion. And when it comes to AGMs and inaugural general meetings, there is a prescribed agenda I mentioned right at the beginning. The last point I'd like to end on is one that we get quite a lot of questions and debates on, and that is quorum of meetings. When is a quorum required to be achieved? Is it at the start of the meeting? Is it only when votes are taken? Is it only at the start of the meeting? Is it at the start of the meeting and during the meeting? So very important to note that you must have a quorum when the meeting is due to start. Otherwise, the meeting will not be validly constituted and you cannot validly deal with the business of the meeting. And the quorum must be maintained at all times, especially when votes are going to be taken. Very often a meeting goes on for many, many hours, and the chairperson starts seeing how people get wriggly in their chairs, and they can say, well, we've got no more voting items. We're only going to discuss issues now, so we can formally declare the meeting closed. And if you leave, it's not going to have a negative impact on the quorum. So very important to make sure that you keep an eye on quorum. And I understand it's difficult in online meetings when people have their cameras off, for example. How on earth do you know if they're there participating or not? But there are systems in place to assist you with that. Peter, I think that's it from my side.
All right, thank you very much, Zelinda. Can I maybe say that we were going to try and work on a guide for meetings so that we could have a written summary, possibly in sort of categories by meeting, by decision, just as a sort of easy guide, because it's quite a complicated topic. There's lots of scenarios and lots of detail. And I think it would be helpful that we work towards that, and we can circulate that down the line as well, or make it available on our training website. And there are a couple of questions, if I may, Zelinda, before we sort of move to wrap up. We've got a few more minutes. Maybe the first thing is, how do you deal with joint ownership? So, husband, wife, etc., or different owners. Who represents the unit? Who's entitled to speak? Who's entitled to vote?
So it's a very interesting question. And when I deal with it in my consulting practice or at meetings, it's one of the first questions I ask is, are you sure that so-and-so is the owner? Isn't so-and-so and so-and-so the owner, or vice versa? And I believe that you should at all times ensure that your records are kept up to date, because there can be a change of ownership. However, the body corporate or the managing agent should be aware of it. But before a meeting, especially a meeting that might be particularly eventful, let's use that word, I would suggest that a deeds office search is undertaken, or a CIPC search if there's companies and CCs, just to double check who the actual registered owners are. And if it is co-owned, the proxy form does need to be completed by both of the co-owners or multiple owners, and they need to appoint one of their own to actually be the proxy holder. Alternatively, both of them can appoint somebody else to be the proxy holder. When it comes to CCs and trusts and companies, the person that has been duly authorized by company resolution or trustee resolution needs to complete the proxy form, needing to appoint perhaps one of the other members or directors or trustees, or a complete outsider. So it's important to fill that out correctly. But the co-owner one is definitely a tricky one, and it's one that often slips under the radar simply because we assume that there are no co-owners or are co-owners. And I've dealt with a few buildings where when the owners sign in with the attendance register, they're like, oh, I didn't know that so-and-so owns this unit with me, which is quite strange, but happens.
And Zelinda, in the case of a trust or company, if the same trust or company owns, let's say, 4 units, I've got a scenario here, and they would like to appoint one of the directors or trustees to represent the units, are they limited by 2 proxies to only represent 2 of the 4? Or would they be a direct representative appointed by the companies without a proxy limitation applying to them?
They would be a direct representative as long as all of those sections are owned in the name of that same entity.
Great. So, Linda, can we talk a little bit about disruptive, unruly, raucous meetings and how to control those? So, first question is, can you ask as the chairman somebody to leave a meeting? And if they won't leave, can security be instructed to remove them from a meeting?
Yeah, most certainly. And as I mentioned earlier, I'm most often invited because a meeting is going to be quite a raucous one, and I've attended quite a few. You can have somebody like a security guard come in and remove someone. I have seen someone physically removed by quite a large bouncer-looking gentleman. I've had someone removed simply because of the peer pressure that has been put on them by their co-owners, like sit down and shut up and or leave or whatever it might be. People can get quite nasty to each other. Or if well, I'm not going to obviously physically go and remove somebody. I wouldn't try maybe in my younger years, but I would stop the meeting or adjourn the meeting until such time as that person left, or we were able to engage with that person to either behave or to leave. Or we would simply adjourn the meeting and call it an evening and walk out, or call it a day and walk out. In other words, end the meeting because of that behavior. Owners don't like it. They don't like when they're having to come back to a meeting because somebody couldn't behave. But again, it depends on the composition. They might all not be able to behave in a meeting.
And so, Linda, you then have to go through a whole notice period again. So if you've adjourned a meeting for whatever reason, you have to convene it with the same notice periods and process you explained.
100% correct. If the meeting needs to happen again, like an annual general meeting, we call it a reconvened meeting. We sometimes call an adjourned meeting a reconvened meeting as well, but there isn't really the word reconvened under the STSMA, rather adjourned, and adjourned is only if it's adjourned because of a quorum issue. So if you are going to call off a meeting or adjourn a meeting or stand down a meeting because of not being able to maintain order, then you're going to have to send out a fresh notice, yes, which is quite an issue.
So when you talked earlier about a quorum maybe falling away during a meeting because it's long or somebody needs to leave, then it would need to be adjourned till the next week to try and reconstitute the quorum, and it's a different threshold of quorum at that time.
Correct. So in other words, to deal with the unfinished business of that meeting, and unfinished business is actually one of the prescribed agenda items for an annual general meeting and a special general meeting, interestingly.
Got a few interesting scenarios here, if I can just quickly ask you those. What happens if the managing agent says they can't provide minutes for a meeting because it was unruly and disorderly, and therefore there is no record, or perhaps only a recording of the meeting?
So interestingly, the meeting that I went to yesterday, that was the exact question that the estate manager asked me, is there wasn't really much of a meeting. What can I minute? So you'd have to minute the formalities, where the meeting took place, when it took place, the date, the quorum, the attendance, proxy representation, any discussions of welcome apologies. We literally got past welcome and then the meeting fell into disarray. So that is what you would minute. And then of course you would minute something politically correct about how members weren't able to behave themselves and the chairperson calling the meeting to an end. And then of course you need to notify the owners of what is going to happen. Is it going to get called again? Are the trustees going to abandon what was proposed? So there must be some correspondence with the owners afterwards. And of course, to ensure that a group of owners don't decide to continue the meeting in the absence of the trustees or the managing agent, which happens often, and then suddenly pass their own resolutions. And before you know it, the next day they're giving the managing agent instruction to change banking account details and all those fun things. So people need to be very aware of what a legal meeting is and when a legal meeting comes to an end.
And Zelinda, can you just talk a little bit about following the agenda strictly and trying to just manage time by avoiding general discussion that's outside of the agenda, and just the chairman's best practices to try and manage that process?
Perfect. So one of the main things of an annual general meeting is that in most schemes, it's the only opportunity that members actually have to come together and voice their concerns, voice their issues, engage, ask questions. And you might attend a meeting with no intention of asking anything, but as the discussion continues, there's something that you wish to raise. From a practical perspective, when I draft notices or when I review notices that have been drafted by my clients, I always suggest that there's a little clause that says, please table your questions, within 48 hours of the meeting or 72 hours of the meeting or whatever it might be, that the trustees are aware of what is going to be discussed and they can prepare. But if somebody has not sent their questions or their comments before the meeting, they can't be stopped from engaging. But in order to maintain the order of the meeting and where the relevant agenda item leads to discussion, I like to use a bit of common law, meeting chairing and attendance to note, we're first going to deal with this item. So, example, if we're going to deal with the budget, we're first going to deal with the levy increase. If we're going to deal with the financial statements, we're first going to deal with, why the trustees haven't signed it or something like that. And I try to give everybody a fair chance to ask questions. So, in other words, not keep on taking the same person asking questions over and over and over again. And then when it comes to a bit of a time crunch, to actually limit the amount of questions that are being asked, to maybe say, we'll take another 3. Another good practical tip is when you prepare for the meeting to actually have time allocations next to each one, very similar to what you did, Andrew, for this webinar, is to say, how long do you think we'll need for this? How long do you think we'll need for that? And to move on, and maybe to hold any discussion items over to the other business or general business. And when it comes to directives and restrictions, most often the directives and restrictions are going to be tabled during the course of the meeting. So you can cut discussion short by saying, we will deal with this under directives or restrictions. Or if somebody asks a question or makes a comment under the incorrect agenda item, just to direct them. So there's a nice way to deal with it. And then there's a not so nice way to deal with it, which very often happens.
So Linda, as a managing agent, you'll sort of identify with this as well. One of our challenges is just to try and keep the AGM annual sort of delivery up to date. For example, there are many owners that won't necessarily be aware, because they're not directly involved, of all the dependencies to convene an annual general meeting. So for a body corporate, it would be an approved budget by the trustees to include in the agenda pack a 10-year maintenance plan, the signed audited financials, a trustee's report, etc. So in some cases, it's very challenging to get all of those documents together, because the trustees literally do not respond, they're not available, they're not interested, whatever the case might be. And that naturally causes a delay, and that delay becomes more severe because budgets aren't approved, levies aren't matched to expenses, and it's not legally compliant as well. So what is your advice in the case of, a dependency that cannot be resolved, just causing an intractable delay in an AGM? And I say it's better to call the AGM with what you've got, to recognize the gaps, maybe have directions to the trustees to close the gaps, or hope that newly elected trustees would address gaps if they weren't resolved by their predecessors.
I 100% agree with you. I went to a meeting during the course of this week where a body corporate presented a budget that was 11 months late. So in other words, they were only proposing 1 more month of a budget to approve. I mean, there's no point in that. When they were supposed to have held it, they should have just gone to the members with the information that they had. Annual financial statements as well, it's sometimes very often delays matters. I'm not going to blame auditors for that. I've got 1 or 2 colleagues that will kick me under the table. Sometimes it is that the auditors don't get the instruction, or it's a difficult time of year for the financial year end. Just a reminder that it's not a legal requirement to table audited financial statements at an annual general meeting. It is possible to hold a special general meeting afterwards. It is also possible to not table for approval a maintenance, repair, and replacement plan at an annual general meeting. You can do it at a special general meeting afterwards. But of course, those documents do have an impact on the budget that needs to be approved at an AGM. So very often you can't approve that item because of the failure to have other items. So yes, calling with what you have and placing directives and restrictions is a very good idea. An example of a directive in regard to finances is that under the STSMA, we no longer have approval of the budget with or without amendment. It's simply approval of the budget. So you would actually need to place a directive on the trustees to go back and amend the budget to what the members wanted to be, to actually exercise the approval that they've given at an annual general meeting.
All right, excellent, Alinda. Well, thank you very much. We've just got the last sort of few minutes, so I'll just wrap up if I may. So we did try and answer as many questions as we can, Karine and I. If anyone didn't have their question answered, we apologize. Our contact details are coming up. You're more than welcome to contact any of us by email, and we'll endeavor to answer any unanswered questions tomorrow or when it suits you. So there are contact details. You're very welcome to be in touch, and we can certainly provide input, feedback, advice as the case might require. Just a reminder that there will be a short survey pop-up. So if you have feedback on how to improve our webinars, we would be grateful. And any topics, like I said, we are very willing to follow your lead on what to offer next. We will be having webinars every third Thursday of the month. From next month, we will send out invitations in advance as before. We will be sending the Q&A record as well as the recording link, if not tomorrow, by Monday. So all of you that left your email addresses, thank you. We will do that. And those that wanted the resolutions guide, we most certainly will send that as well. So I'd like to thank you, Zelinda, for your time, for the very informative presentation. The slides will reflect as a record what you said. I think it's very helpful, and we will try and circulate a guide to meetings in a couple of months, which then gives a nice, prompt or primer for anyone that would like to refer back to how to run effective, legally compliant, and well-organized meetings. So good night, everybody. Thank you very much, and we look forward to seeing you next month in March. Good night.
Bye-bye.
Bye.